listing agreements to the homeowners at the time of execution. Now, Eric, as you and I both know, listing appointments happen, by and large, at the home, at the person's home. What the state is saying is when I'm out on that listing appointment, once they sign the agreement, I have to photocopy the agreement right then and there and hand it to them. Eric, I don't know any real estate agents nationally that carry a copy machine in the back of their car. And unless you're carrying a copy machine in the back of your car, you are not able to comply with what the state is saying is the standard of the industry. And so, again, here they're very, very out of touch with them. Now, what we did was we provided them. We would carry 2 sets of the contract with us because the state forms are no longer on NCRs, the non-carbon reproductions like they used to be.
Right.
And so we print out 2 copies of it, one that they keep and one that we take with us.
Mm-hmm.
And we would provide them with their copies. But the state here is saying that's not enough. You actually have to have a copy machine there, and you have to photocopy it and hand it to them at the listing appointment.
Wow.
That's absolutely ludicrous. That is absolutely ludicrous.
So, but you're saying you are bringing an extra set of the listing agreement?
Every time. Every single time. We have a pre-printed packet. And so on the left-hand side is everything, and this is part of my listing presentation that we do. On the left-hand side is all the documents we're going to leave with them. On the right-hand side is everything we need them to sign and get back to us.
Right.
And on that left-hand side is their copy of the listing agreement that they signed, and it's always the same every single time. And so it's really not rocket science. The challenge is that nobody's going to carry a copy machine in their car with them. And so, it's interesting because also as a piece of state law, we are responsible as part of agency law that we will practice, that we will run our practice in accordance with industry standards. Well, if the industry standard is not to bring a copy machine with me on the appointment, then as part of agency law, does this make sense? So now they're putting me in the position of violating it when I'm darned if I do, I'm darned if I don't.
Right.
So if I bring the copy machine along and that's not part of the industry standard, well then I'm in violation of agency law because or rather not that if I bring the copy machine along, but if I require them to come to my office, let's say, for the listing appointment. And as we all know, as a practical matter, how many of my sellers are really going to come to my office for a listing appointment? And what is that going to do to my ability to make a living?
Sure.
So, another one is dilatory communication with homeowners. They're saying that we weren't communicating with homeowners in a timely fashion. We talked about this one earlier as well. In 99% of those cases, the challenge was not that we weren't calling the homeowner back. The challenge was that we weren't getting information back from the bank. And so, again, good news, bad news, or no news, you need to call the homeowner back and you need to let them know what's going on.
Mike, how many allegations are there?
There's 9, I believe, and I'm down to the last 3 now. We've gone through all but 3 of them.
Let's go ahead and knock the next 3 out, and then we're going to open up the line for questions.
Absolutely. Okay, so here's one. Drafting addenda to the purchase and sale agreement as part of the counteroffer stating that the seller has requested that the buyer pre-qualify through a certain lender. Eric, you are the perfect person to be talking about this one with. Builders have done this for years. Every builder in the country, particularly every major builder in the country for years, has requested that buyers pre-qualify through one of 2 or 3 lenders that they would recommend. Right. This doesn't mean they have to get their loan through that lender, but they want them to pre-qualify through that lender so that they know the person is qualified to buy the home.
Right.
Banks on REO properties are doing the same thing. And if they're contributing to the homeowner's closing costs, they will require them to use that lender if they want those closing costs paid for by the lender.
Right.
And so what the state is saying here is that we did this without this, that we drafted these addendums without the seller's without the seller's understanding. Well, wait a minute. Before that addendum was submitted to the buyer, the seller had to receive the addendum and sign the addendum and send it back to us before it was sent to the buyer.
Right.
So to say that it was done without the seller's knowledge is ludicrous because every one of those was signed by the seller, so it was the seller's request. And if it wasn't the seller's request, they shouldn't have signed the addendum.
So on your addendum, you specified a particular lender to be pre-approved?
Yes, we gave them a list of 2 or 3 lenders, and we said, not pre-approved, just even pre-qualified.
Okay.
We just want them to get on the phone with this lender and at least pre-qualify so that we know that we're not going to spend the next 3 months trying to get their short sale approved, and all of a sudden at the end we find out that the buyer wasn't even qualified and that their lender, as many do, lied about their ability to qualify. Or perhaps overstated how deeply they've dug into this person's financial background.
Right.
So again, a good example of where, the state is very out of touch with what's going on and clearly is on a witch hunt. Here's another one, telling homeowners they must vacate their homes before they were legally required to vacate. Let me tell you what this stems from. This complaint stemmed from a Fannie Mae cash for keys. So Fannie Mae has a cash for keys process wherein we are required to give the homeowner, upon foreclosure, we are assigned the property. We then go to the homeowner, we give them a notice that your home has been foreclosed on, and here is a brochure called the Knowing Your Options brochure. We gave the homeowner the Knowing Your Options brochure. We also give them at that time a copy of the cash for keys agreement. Homeowner not only read the brochure and read the agreement, but signed the agreement, moved out of the house, and was given the cash for keys, and only after all of that happened did they file a complaint saying we made a move before they were legally required to. So here the problem is not my team, the problem is the federal government. So if the state has an issue with this process, it's not me they should be coming after, it's Fannie Mae they should be coming after. Now, do you think Fannie Mae jumped up and said, hey, we're going to come to your defense on this? Of course not. And so this is a perfect example of where agents that are handling REO properties need to remember, as well acquainted as you think you are with your asset managers, and as much as you'd like to believe that if something like this happened to you, don't think for a second that they're going to be there backing you up if the state comes after you for their process and takes issue with that process. You're the one who's going to be on the line for this, not Fannie Mae, not any other company out there. It's going to be you.
So the borrower filed a complaint stating that you forced them to move. I guess, did they have a modification pending? Were they trying to hold on to their home?
No, the Fannie Mae had already foreclosed on their home.
Oh,
it went through the process. It was foreclosed on. So basically, when we go out,
their
right? Well, and when we go out there, when given the Knowing Your Options brochure, the options are, we can wait 20 days and begin the evictions process, or we can give you cash for keys.
Right.
And those are basically the options. And so we did all that, and we gave them the brochure. And they took the money. They moved out and cleaned it up and took the money, and then they filed a complaint. And really what this is another instance of a homeowner who is trying to get something they're not entitled to. It's really they're just looking for every dollar they can find, and they're thinking, well, gosh, if I sue the real estate company, or if I sue Fannie Mae, or if I make enough of an issue, maybe they'll give me more money.
Incredible, Mike. Last one.
And this is the last one.
All right.
Falsely advertising that Michael Hellickson and his team of experts can provide everything from zero-down loans to super jumbo loans at the most competitive rates in the industry. Well, here's my real challenge with this, Eric. Number one, zero-down loans still exist. Eric, can you give someone a zero-down VA loan today?
Yes.
So zero-down loans do exist, correct?
That's right, they do.
And let me ask you this. If I'm working with you as my lender, are you a part of my team?
Yes, I am.
And so this is a frustrating. I used to own a mortgage company, so I used to actually have that at house, and I went away from that to avoid liability, and I started working with outside lenders and making those outside lenders a part of my team. And so the state here is saying that I'm falsely advertising that my team can do this because you, as my loan officer, are not a part of my team. And what I'm saying is not only is my loan officer a part of my team, but so is my accountant, my attorney, and all the other professionals that we've built relationships with that are there to help our clients.
Seems so petty.
So tell me if there's any one issue. Can you think of anything they've accused me of, any of it, that one, agents all over the country aren't doing every single day, and two, that really constitute any kind of a legal, ethical, or moral violation of any kind, and three, anything that even if we were found guilty of anything that would warrant a suspension?
Well, I'm going to let our audience answer that question. We're going to open up the lines for Q&A now. And if you have a question, the operator is going to give you instructions in just a minute. But I would tell you this, Mike, the fact that you have not been proven guilty on any of these points, that you have sued the state and won on various civil rights issues, that speaks volumes. And I'm just amazed on how you've been impacted. I know that you had several workshops scheduled even in this area, and all of us pulled back from you because of these very serious allegations. And now that we're hearing this, I'm sure that it's got a lot of people thinking and perhaps even changing their mind. So, operator, let's open up the lines for Q&A for a few minutes. We're way past time, but we're going to give a couple of questions, and then we're going to go into announcements.
Certainly. Ladies and gentlemen, if you would like to queue up to ask a question, please press star and then 1 on your touch-tone keypad. Once again, if you would like to queue up to ask a question, please press star and then 1.
So, Mike, I'm glad this is a two-parter. Ladies and gentlemen, this is part 1. Part 2 will be next week, and we're going to cover what we didn't get to cover today, as well as dive into some of the strategies that Mike has to offer for developing REOs and working with short sales. Operator, do we have any questions?
Yes, our first question comes from Latoya James. Your line is open.
Hey, Latoya.
Hi.
I was talking about you this morning.
I know. I wanted to actually chime in and give a testament to what you did, but I'm going to say to Mike first, it was really an eye-opener listening to all that has transpired with you because, of course, as an agent, everything that you're being accused of doing, we do. So knowing our civil rights and knowing what to look out for, and I'm glad that you made yourself available to us if we should run into that situation because, man, we carry a copy of the listing agreement and we just give them a copy because they, that's what we do. We don't carry a copy machine. So, but I wanted to say about the Do It Now team. Martha is my rep, my consultant. I had a
Hello? Latoya, did we lose you? Operator, we may have lost Latoya.
Yeah, I'm sorry. It looks like we have lost Latoya.
No problem.
Once again, if you do have a question, please press star and then 1 on your touch-tone keypad. And our next question is from Desi Blaszewski. Your line is open.
Hi, this is Bessie. How are you?
Great,
my question is, I use DocuSign, and won't that be sufficient? I mean, the seller would have an actual copy online. Would that be sufficient when you're taking a listing up, when you're listing the property?
Mike? Okay, looks like we may have lost our guest. Operator, are you there?
Yes, I'm still here, and I show Michael's line connected, but...
Sorry about that. Can you hear me now?
Okay, we can hear you now, Mike. Thanks.
Okay. So ultimately, we would love to believe that, yes, in fact, that will be enough. And I would venture to say that it is, but I would recommend that you consult with your attorney on that. Really the challenge comes for most real estate agents when they're on the listing appointment, they go to the person's home and they have them sign the listing agreement at the home. And, your question is a good one, and it may be that the bar gets raised and that now, we may get to an era in the real estate industry where, we're carrying tablet PCs or, iPads, and we're having them sign the documents right there on that iPad and emailing it to them as we sit there with them. That may happen, and that may be one of the results that comes of all this. But I would say ultimately, I would feel comfortable if my agents were using DocuSign. I would think that would certainly help get around this issue, but I think you should check with your attorney just to be safe. And keep in mind that in all of this, even if you and I and your attorney agree that you're doing the right thing, that doesn't mean the state can't do to you what happened to us.
Does that answer your question?
Yeah.
Okay, thank you for calling.
Thank you.
Operator.
Thank you, and I show no other questions in queue.
Okay, so we're going to take that opportunity to move into announcements, Mike, because we're way past time. So I want to encourage everyone on the call to call back in next week.